rise. Court of Appeals Division 1 is now in session.
Good morning. Thank you. You may be seated. We're here this morning in the case of 34 Degrees North versus Mountain View Construction and Maloof and Company. It's our case number CV150646. These proceedings are being audio and video recorded, so we would ask that you identify yourself and your client when you approach the podium. Each side will have 20 minutes. Counsel for appellant, you'll be required to reserve any time you'd like for rebuttal. We have conferenced this matter already this morning. We've read the briefs. We hope we're familiar with the facts and the argument, but we look forward to hearing from you. And with that, you may proceed.
May it please the court, my name is Wayne Ducharme, Ducharme Law Firm. I'm representing 34 Degrees North, the appellant. Plaintiffs in this matter, they are the owners of a small commercial building that is incomplete, unusable, and may have to be torn down. As a result of the defective work by contractors, they are suffering financial devastation and had no justice at the court level, the trial court level, due to the motions for summary judgment. So we're requesting the court to vacate the summary judgments in favor of the defendants and remand the case to the trial court for trial on the merits. And this argument really is in two parts because there's two separate issues. One has to do with the preclusion of the ROC hearing as applied to the trial court, and the other is a standard of proof required for a contractor defective workmanship. So there's two parts and two defendants in regards to that. I think the faulty premise by Mountain View Construction that was argued and accepted by the trial court is that a short hearing at the ROC really constitutes a trial on the merits of a case, and that the preclusive effect applies even though it's a limited jurisdiction of the court to hear violations of contractor licensing, that the trial court and Mountain View has argued that other superior court decisions apply as if there are two trials when really there's only one trial on the merits of the case.
Counsel, let me ask you this question.
Yes.
Even if you're right on,
yes,
on the preclusive effect and that there isn't, doesn't your case against MVC also have the same problems that it has as it relates to Maloof in terms of the do you
mind speaking up a little bit, Your Honor?
I'm sorry.
Yes.
The issue as against Maloof, as you characterized it, is that it has to do with the nature of the expert witness proof, and that the court ruled against you on that issue. My question is, as it relates to a Mountain View, even if you're right on whether the ROC findings have no preclusive effect, doesn't your case against Mountain View also fail for the same reason it fails against Maloof?
Well, first of all, I don't believe it fails against Maloof.
I understand that, but isn't it sort of the same issue?
No, Your Honor. I mean, if you look at the Hardy case that this court recently decided in January of this year, many of the same issues came up. Now, in that case, there was a contractor who performed defective construction on the concrete. The ROC found that the work was defective. The contractor corrected the work. There were certain claims that were not made by the homeowners at the ROC hearing, and the trial court granted summary judgment in favor of the contractor, saying, well, you didn't bring up damages at the ROC hearing, he corrected the work, and so on. And this court overruled that. This court said that you can have a trial on the merits of the case, regardless of the findings at the ROC. So one exception would be, let's say that the ROC found that the concrete was acceptable, that the workmanship was acceptable. Well, then that would be preclusive effect. But in our case, there were many, many, many items of work that were not corrected. The building was too high. The walls leak like a sieve when it rains. I mean, there's just a lot of defective work that have not been corrected. And the excuse was that, well, my client didn't allow them back on the job, didn't allow Mountain View back on the project to complete the work. Well, they didn't want to let them back, and they weren't obligated to let them back because they had done all the defective work. Basically, a residential contractor who is attempting commercial work no longer has a commercial license, just has a residential license now. So there was a lot of defective work that was never, ever corrected and remains uncorrected to this day. So I don't see how our client has not suffered damages, at least for the cost of the corrective work. In fact, the ROC found that there was actual defective work, not just excusable work, but defective work such as space over the lintels, some problems with the concrete, and so on. So there was an actual finding of defective work, and the contractor's license was suspended for a period of time. So there clearly was some damages that our clients were entitled to pursue because the ROC cannot give damages. The most they can do is restitution. They cannot have an enforceable judgment for damages. So the only place you're going to get damages is in the Superior Court.
Okay, well, my question really, I understand what your argument is as it relates to preclusion. My question really dealt with the nature of the liability proof in the Superior Court and the basis of the judgment in favor of Maloof, whether it's right or wrong. My question is, doesn't that apply to MVC, even if you get there?
We have two experts. We have an expert structural engineer who's very familiar with all types of construction. We have an expert who is a construction expert. Not only did he calculate the cost of doing the work, but he pointed out the defective waterproofing and so on. So we have experts that will testify as to the level and workmanship and defective work. I don't know what more you need, Your Honor.
I understood the experts had a question about causation, that they were not asked to specifically go into causation as between the different.
Well, they weren't asked to do that at the deposition, but I certainly have directed them and in the trial to go into the issue of causation, to go into the issue of all the testimony that's required to prove not only the damages, but to prove causation. Well, first of all, let me just say one.
And is it your position that you properly disclosed those two experts as it relates to not only standard of care against these two contractors, but also causation?
Well, the standard of care is found right in the ROC. The standard of care for workmanship is right there.
He's asking about causation, though.
Yes.
Did your experts, did you properly disclose their testimony relative to causation?
Yes, specifically with respect to, at the deposition, there was discussion about the waterproofing. We went through some photographs that showed that the waterproofing was leaking. There was excessive leaking. We had a lot of photographs after a rain. Prior to a rain, there was a lot of markings on the...
Causation could go to, it could be an architect, it could be a lot of different things. What was the disclosure as to who caused the water damage?
The water damage was caused by the contractors. Now, the original contractor was Mountain View, who did the original, and we have photographs showing, and we disclosed those, photographs showing that the wall was improperly waterproofed, and then we found after Maloof took over, they did waterproofing, they took over and completed, but it was still leaking. So, I mean, it's straightforward. If the water is leaking, the standards show that if you have a leaking waterproofing, you have defective workmanship.
You could have a defective design. There could be several reasons, it seems to me. Don't you have to disclose whose fault it was? That it wasn't as a result of the design? If the contractor was just carrying out the design and acting at the direction of the property owner, don't you need a causation expert to explain who is responsible?
The contractors who did the work are the ones responsible for their own workmanship. When it leaks and we have photographs showing that the waterproofing was incorrectly applied, hanging and not properly installed, it clearly is a workmanship issue, not a design issue. We pointed that out repeatedly. It's in the experts' reports. It's in the photographs. It's in the deposition. The other thing that's important is that with respect to res judicata and collateral estoppel, the burden of proof is on the defendants since it's an equitable process. It's an equitable defense. They haven't proved that the workmanship was proper. I mean, the building is 5 inches too high. The blocks are mismatched. There's a lot of issues in there that were never corrected by the contractors. And so they haven't proved that that work was correct, merely that the ROC said they didn't have to do the corrections because the contractors were not allowed back on the job to do the work. So that's where we are with that. It seems like the court is more concerned about not the standard of workmanship, not the defective work that was performed by the contractors, but what the testimony of the expert will be at trial. We didn't get to trial yet. We didn't get a chance to go to trial.
Well, I think the concern is that when you are challenging a motion for summary judgment, you have to put evidence forward that says you should go to trial by showing whether negligence or contract, not only a breach, with resulting damages, much less monetary damages, but how that was caused, whether it was one, both, or all of the actors involved with the idea and development and construction of the business. And so that's why we're trying to get a handle on exactly the facts that would preclude summary judgment on that issue by saying that, your expert said clearly MVC or Maloof was negligent and they were the cause of these damages for the following reasons. As opposed to it was Mr. Catone's negligent design of the project. That's what I think we're just trying to focus on a little.
Well, with respect to two specific issues that the court, the ALJ found at the ROC level, was that there was some problems with the concrete, very specifically, and there was spacing over the lintel with respect to those two. The court clearly could have found that those were issues that did not allow summary judgment because there was a specific finding at the ROC level.
Do those issues? I'm sorry. Go ahead.
Well, all I was going to say is, in looking at your expert's cost of repair estimate, he's attributed nothing in terms of repair to either of those issues.
Well, I'll take a look at that. I recall that he did.
Well, I don't want you to take your time up right now.
I looked at it this morning, Your Honor, and there is specific for those items. There is a cost of repair. I believe it's $8,700 and some odd dollars for those particular items. And there was a specific finding at the ROC level regarding that. I'll save that for rebuttal, then. I'll come back and take a look at that. I want to reserve the rest of my time for rebuttal, unless you have any further questions.
Thank you.
May it please the court. Good morning. My name is Matt Pierce. I'm with the law firm of Warner Angle, Hallam, Jackson, and Fermonic. and I represent Appellee Mountain View Construction, LLC. With me I have my associate Tara Nordquist, and at the table as well as, of course, co-counsel with Appellee Maloof and Company Masonry. We will be dividing our time up equally, or as equally as the court will allow us, to basically 10 minutes apiece. The briefs in this case sufficiently detail the issues, with the exception of two, which are the subject of the motion to strike that was filed, and I know that that's generally taken care of at oral argument. I would even rest on the briefs from the motion as well, that the issue, and it was brought up in the opening remarks, related to the Nick Hardy-Nyberg case. That case, not only as it being unreported, it was presented for this concept that complainants are not parties to an ROC case. That's dictum, in my opinion, and any member of the construction bar would say that's the same, that's the issue. And there is a case that's on point, and that's the Cayetano case, if you've looked at that, and that was in footnote, I believe, 4 of the answering brief. But we would ask that that aspect of, it was the citation, the additional citation of authority, that be stricken. What I would prefer to do, and just rely on any questions that the court may have, but I do want to point out what is not contested in this matter. And first, the judgment of the summary judgment that was made by Judge Brain as to consequential damages. That has not been contested. And it's really, there's a simple reason for it. It can't be. The contract's pretty clear that damages such as financial harms, financing harm, or loss of profit, loss of rent, things like that, cannot be accepted. And it was the plaintiff's appellant's position, in their settlement position, and their demands, that they were entitled to those types of damages. That's why the motion was made, and it was granted, and it still hasn't been contested. So that still should be affirmed. Second, there's been no argument related to the award of attorney's fees that has been made as to the reasonableness or the entitlement of it. Obviously, there's the underlying case as to who's a prevailing party, but entitlement and reasonableness has not been argued, and that should be affirmed as well, including the sanction that was made for the offer of judgment that Mountain View had made. Next, what has been uncontested from the very start, that is until that supplemental citation to authority, were the elements of collateral estoppel, okay, or issue preclusion. Those 5 elements were set forth in our original motion for summary judgment. In fact, in the response, and it was a cross motion by plaintiff's appellant, they had said, hey, we're entitled to summary judgment because collateral estoppel rules in our favor. So they were even accepting that collateral estoppel applies in the ROC case. And there's really little argument that it does not, given the J.W. Hancock case. It says that collateral estoppel, or issue preclusion, does apply. So those 5 elements were never contested. It wasn't until the supplemental citation of authority that they were. As I said, the briefs sufficiently describe the issues. Unless the court has any questions, I'll release the rest of the time to...
What's your response to the argument that there's an allegation that there's at least $8,000 worth of damages tied to the findings of the ROC?
That's news to me, Your Honor. So the issue of...
But you agree there were some findings of deficient work?
Oh, absolutely. Yes, and this then goes to your question, Your Honor, Judge Winthrop, about the law of the case related to damages being provable and the expert issues. Yeah, in fact, the voids in the lintels and the drag marks in the concrete, okay, there were no damages ever associated with those issues. They went to the bigger picture. They say the building needs to be torn down, essentially. Being that no damages were disclosed, the court could have said, yeah, I find liability. It's that these issues are collaterally estopped because the administrative law judge found in favor of the complainant on those 2 minor issues, and therefore let's have a damages hearing. But at that damages hearing, we wouldn't have had anything specific to prove. It would have been pure speculation. And what's kind of sad is it's such a minor thing. We would have been in small claims court. It was not an $8,000 issue. These are very minor concrete patches that we're talking about. But the plaintiffs could have easily disclosed some minor damages for that issue had they wanted to, but they didn't do it. And they left a lot of things for a trier of fact to just try to guess at. For example, you talk about the waterproofing. You may not know, I don't know if you've, to the extent you've looked at the photographs, but the waterproofing is continuous between the work performed by Mountain View and performed by Maloof and Company. So at some point, somebody needs to testify, this is the waterproofing that's failing, this is the waterproofing that's not, and here's who caused the damages, and that was never done. And their expert in discussions on that in their depositions said, yeah, it would be speculation to try to do that.
Is there a question about whether it relates to someone other than the two contractors?
Yes, in terms of the architect that was involved, and not so much the waterproofing. I mean, there wasn't a whole lot of discussion about whether the specification was appropriate or anything of that nature, but there are other aspects to the alleged defects that could be attributed to either the architect or the engineer that was hired by the architect. But yeah, there was a mixed bag of folks who could have been responsible for various different things. But the administrative law judge found that Mountain View was not responsible for those things. And appellant wants to say, well, there were these issues that weren't decided.
Was that not responsible because they were willing to go in and remedy the problem but were kept from the property?
No, and that's actually a very minor aspect of what the administrative law judge had said. What she had actually said was that with regard to departure from plan specifications and codes and standards and those types of things, that the appellant did not meet its burden of proof with regard to those things. And the burden of proof at the administrative law judge, in administrative hearings for these types of matters, is a preponderance of the evidence, just like in civil matters. And we're talking about the same standards of care, the same alleged defects, the same burden of proof, and they did not prove it. And that's not to mention that Mountain View Construction showed up at that administrative hearing without counsel and was still able to defeat those items. If there are no other questions, I will relent to, or release time to my co-counsel here. Thank you, Your Honor. Happy Thanksgiving.
Good morning, Your Honors. Thank you for allowing us to explain our positions this morning. I wanted to focus on just a few things because I think the record is full of a lot of information that supports our position. The case was certified by Mr. Ducharme as a case that required expert testimony. He filed his certificate with his complaint. So the case started out as one that necessitated expert testimony. And ARS 122602 is pretty specific as to what's required, and it's for each claim against each claimant. Maloof, just as MVC, are licensed professionals, and when a case is brought against a licensed professional, an expert is needed to establish causation and damages. And that wasn't done in this case. Plaintiff's certificate was never amended, withdrawn, modified in any way. And 2.5 years later, when we filed these various motions, plaintiff had not disclosed an expert on causation at all. There's been some discussion about perhaps the difference between a negligence case and a contract case for purposes of whether this certificate applies and the level of proof that's necessary. I think Woodward versus Churko talks about that. The Supreme Court decision talks about essentially that these cases have similar elements of proof. But in this case, the reason, especially with Maloof, that it was so important for the plaintiff to supply an expert to testify about causation, in other words, who did what, which defendant caused this particular damage or any damage at all. In the contract cases, because when Maloof entered the contract with the plaintiff, Maloof specifically carved out responsibility for anything that MVC may have done before it. Maloof was the second contractor on the job. We were only on the job for about 3 months. When we took over, we understood that there were problems. We came in to try and help the plaintiffs figure out what was wrong and try to fix some or all of it. When we started, we realized just how problematic the project was. And so we weren't able to do much of anything at all, and then the project was very quickly shut down by the county, by Gila County. The reason the project was shut down was because the building was not designed properly. Neither of the contractors could have fixed what the design team, the architect and the engineers, had set them up for. Ron Starling is a very fine expert. Ron Starling is an engineer that we rely on for complicated structural explanation all the time. But Ron Starling is not a contractor, and he can't testify as to the standard of care of a contractor. All Ron Starling's report did was tell us that the project was defectively designed. If you read his affidavit, it's limited to design issues. Tom Cross is also a qualified expert. Tom Cross looked at Ron Starling's report and provided a cost of repair in general for the building. Again, and Tom Cross testified very specifically that his cost of repair was tied to Ron Starling's report and nothing else, period, I believe is what he said. Neither expert was ever disclosed by plaintiff to testify about anything more than design issues and overall cost of repair, items that are properly pled against the architect and engineer that designed this building. Ron Starling and Tom Cross were both asked very specific questions in their depositions about the scope of their testimony, and each one of them said, I can't and I won't testify about who did what. I can't and I won't testify about causation because I can't do it. Tom Cross, I believe, said, I can't answer that question, I just flat can't. So neither expert was either retained or was capable of telling a jury which one of the defendants, whether it's MVC, Maloof, one of the engineers or architects, was responsible for the damage. And as I'm sure you're very aware, construction cases like this are complicated. This was a complex construction defect case. There were numerous problems created by engineers, architects, and the county by not properly inspecting the building as it was being built. A jury cannot possibly understand causation issues without proper expert testimony. It was so important in this case, and it wasn't done.
So you don't think it can get to the jury based upon causation for at least for the jury to determine whether Maloof was 1% responsible or 90% responsible vis-a-vis MVC?
That's right.
Okay.
That's
So
right.
there's not even a way that they can point the jury could make the defendants point fingers at each other as having some responsibility for causing the water damage.
I don't think the jury could.
And you're also suggesting that that also applies to liability for someone else who didn't remain in the lawsuit, whether it's engineer or an architect?
I think so. I think they would be up here saying the same thing I am, that nobody can explain to a jury how to attribute, whether it's a percentage or whether it's a specific dollar amount. There's nobody to guide the jury on that. It's pure. The jury is now being forced to speculate, and there's a jury instruction that we always focus on when it comes to that. The jury's not supposed to speculate. So we're left with a very, we're left with a case that can't proceed to a jury based on the way it was set up. And with that, if the court doesn't have any more questions for me, I'll stop now.
On the estimate that was presented at the deposition regarding by Tom Cross, there is a dollar amount specifically of $8,486 having to do with the reinforced lintels that were not done per the plans. So we did have a dollar amount. We do have a dollar amount for the concrete. Leaking waterproofing, that's $80,000. Now, one of the reasons that Tom Cross said he couldn't tell what percentage was whom's because the walls were covered up. It's not as if the walls were exposed. The walls were covered up with dirt. So you'd have to dig up the dirt to see what was done to the walls and who did it. So at that point in time, he testified at his deposition when it was taken that he couldn't tell who was responsible in terms of percentage versus Maloof versus Mountain View Construction.
Did he specify that it absolutely was not caused by the architect or engineer?
That's correct. Was not correct. In fact, right here is a photograph that's an exhibit. And this photograph was part of the deposition, and it's in our appellate brief, and it clearly states, and it's photographs of the waterproofing being installed, and it says here, note, workers standing on footing. Placed properly, waterproofing should have started at the edge of the footing with overlap. It did not. Note, walls partially backfilled. This procedure would have damaged the waterproofing. Walls should have been waterproofed in a continuous operation.
But even assuming there's a problem with that work, does that still dictate if it's designed improperly, even if you properly waterproof it, one particular part, does that necessarily establish that that's what caused the damage?
Clearly, Your Honor. Clearly, Your Honor. If it says that it's improperly installed, it's not the design. It says you shouldn't be standing on the edge of the footing. I mean, the waterproofing should be going over the footing, and they're backfilling and damaging the waterproofing. That is not design. When you're backfilling and damaging the waterproofing, it's clearly a workmanship issue. The other thing is...
It can't be both a workmanship issue and also a design issue?
Well, how could that be, Your Honor? I've been in construction for close to 50 years, and the design issues and construction issues are quite separate.
So,
I mean, in terms of workmanship, workmanship is a construction issue, not a design issue.
excuse me for interrupting. So,
sorry.
As it relates to then your allegation that one or both contractors failed to comply with the applicable standard of care.
Yes.
Which of those two experts that you disclosed was disclosed to testify to that?
Both, Your Honor. Both because Starling is very knowledgeable about construction and about not only structural, but the actual waterproofing and things that go on it, because he works with architects all the time, and he did testify as to that. And also Tom Cross, who's a very knowledgeable contractor who knows how to install waterproofing. And he said he would testify that it was improperly installed. I was at the deposition Mr. Rigai was not at the deposition. He didn't attend any depositions. So he could have asked certain questions about standard of care or whatever he wanted to do, but he didn't.
What can you point to that shows which expert would have testified to causation? Is there a
I'd be happy to submit a
a
supplemental brief, Your Honor, pointing that out specifically. At this point, when I only have 2 minutes left, I don't have time to look through all my paperwork.
It is in the deposition testimony? Or
Yes,
where is,
I'll be happy to submit it, Your Honor. May I?
we'll look through the record and we'll determine if we want, we'll request supplemental briefing if we decide it's necessary.
May I point out to Your Honors where the testimony is located?
Sure.
All right, thank you, Your Honor. I'll do that. Oh, incidentally, consequential damages is not an issue in this case. It's cost of repair. Consequential damages, as defined by the contract, have to do with lost profits, extra financing charges, a lot of other things that we have not made a claim for. Thank you, Your Honor.
Thank you, all of you, for your argument. We'll take this matter under advisement and issue a decision in due course. And with that, we'll stand at recess for a few minutes.